Okay, my name is Suzanne Stoltenberg. I work at NFIB Pennsylvania as a communications person, and I welcome you to our webinar on employee hiring best practices. We have an excellent presenter today. That's Adam Santucci, who's an attorney, a labor attorney, and he will begin in just a moment. But first, I'd really like to thank our sponsors. So let's put up that slide. McNees Wallace and Nurick, a law firm, have sponsored us, Capital Blue Cross, also Pennsylvania Manufacturers Association, and Members First Federal Credit Union. Now, before we begin, I just want to let you know that you are welcome to enter questions, and you can type them in, and we will try to get to all your questions. If for some reason we don't, I would be more than happy to email you an answer or refer them to Adam if it is a question that I cannot answer that he can help us with. So let's begin. Adam, I now throw it over to you.
Great. Good morning, everybody, and thank you, Suzanne. We appreciate the opportunity to be with you and your members this morning. I am a labor and employment attorney with McNees Wallace and Nurick. In the labor and employment group at McNees, we represent businesses of all sizes, and we help them deal with all sorts of workplace issues and disputes, from employment litigation involving wage and hour disputes, harassment, discrimination claims, etc. What we aim to do is work with our clients to be proactive, to help develop policies and procedures that keep them out of legal trouble and help them remain compliant while doing the good work that they do on a day-to-day basis. As Suzanne indicated, we'll be happy to get your questions answered today during the presentation, or if there's not enough time for that, I'll be happy to follow up with you after the presentation to get your questions answered. Our topic today is best practices with respect to employee hiring. Employee hiring and compliance in this area is certainly a moving target. You probably have heard discussions about the skills gap and the war for talent, and you may have heard your colleagues lamenting that there's just not enough good workers out there anymore. All of these people issues are facing small businesses, and that's on top of the legal requirements that you face when you're hiring and bringing on board new employees. This morning, we're not going to be able to solve the wage or the skill gap, but we are going to talk about how we can help you remain compliant with the law when you're bringing on new employees. And here's a brief overview of what we're going to cover this morning. We're going to talk about your job applications, some best practices in that area. We're going to talk about social media screening and the cost and benefits of using social media to screen applicants. We'll also spend some time talking about background checks and criminal history inquiries. We'll talk a little bit about drug and alcohol testing. We'll go over some of the dangers of I-9 compliance and non-compliance in the I-9 employment eligibility verification process. We'll touch briefly on health and religious accommodation issues as they pertain to hiring. It seems to be a burgeoning area of the law. And we'll conclude briefly with a discussion of union salting and concerns about union organizing activities that may come up in the hiring process. We will move relatively quickly to ensure that we can cover all of these topics, but we'll make sure that we hit the high points along the way. Let's start with taking a look at job applications. For most applicants and employees, this is going to be their first touch or first experience with the organization. In addition, if there's a problem, it might be the first place a government agency starts to look at your organizations by determining whether or not your job application is lawful and legally compliant. On the screen here, we have a number of best practices that we recommend with respect to your job application. It's always a good practice to keep the at-will employment statement on that job application. We advise applicants that if you are hired, your employment will be at will, which means we can sever the employment relationship at any time for any reason, and the employee can sever the employment relationship at any time for any reason. We also want to make clear to candidates and those government agencies that we're an equal opportunity employer and that we will not discriminate in the hiring process with respect to race, religion, color, gender, national origin, ethnicity, or any class protected by law. We'd like to put that right at the beginning, probably right under the company logo on your job applications. It sends the right message. It ensures that you're lawfully compliant. And again, if a government agency happens to pick up your job application, it sends the right message to them as well. We also want to put in the acknowledgement or the verification section of the application that just completing the application doesn't guarantee employment, and that may seem a little bit unnecessary or a little bit remedial, but it is a good practice to include that. Also include in the acknowledgement that the candidate may be subject to further screening and or testing, whether that's a post-offer drug and alcohol test, whether that's a criminal records check, whether that's a credit check. That further testing and screening will be required or may be required of the applicant. We like to put that right up front. In the event that there is later a dispute, we can point to the application to say the applicant signed an acknowledgement, recognizing that further screening was possible. We also like to obtain a written authorization with a signature to check references and call those references. And then again, something that's probably you've heard before, but always include a truthfulness statement. Always include a statement that says the representations in the application are accurate and truthful to the best of the applicant's knowledge, and that if we discover any false or material omissions at any point, even after the employee is hired, it would be grounds for termination. So always include that truthfulness declaration to protect yourself in the event that we later learn that information on the application may not have been accurate. Moving on to slide number 6, some things to avoid on the job application and the job application process. Probably the biggest thing to avoid is soliciting either directly or indirectly protected class information. We don't want to know and we don't need to know any information about race or age or religion or child care responsibilities, disabilities, prior workers' compensation claims, bankruptcy, height and weight. Any other protected class status is not something we should be trying to get at on the job application. Again, this will be a red flag for any government agency, and any employee who happens to not be selected would point to any such question and indicate that it is discrimination or evidence of a discriminatory intent. We are allowed to ask if the individual applicant is authorized to work in the United States. Note that that's a different question than, are you a U.S. citizen? We're not allowed to ask about citizenship, and we shouldn't ask about citizenship, but we can and should ask, are you authorized to work in the United States? We should avoid on the application process asking about English language skills. Now, it is true that certain jobs require the ability to speak English. However, we don't need to necessarily obtain that information on the application. We can obtain that later in the process. Also keep in mind that the Equal Opportunity Employment Commission would say that not every job requires the ability to speak English, and only those jobs where it is job-related and consistent with business necessity can require English-speaking employees. That's a little bit beyond the scope of the webinar this morning, but just keep in mind that we shouldn't be asking about English language skills on the job application. Also keep in mind that if we're going to ask about criminal background information, we have to make sure we ask that question appropriately. In Pennsylvania, we can rely on felony and misdemeanor convictions that are job-related. We'll talk a little bit about that in a minute, but if you are asking about criminal history information, we have to make sure that that is an appropriately tailored question on your job application. We should not be asking about arrests, just convictions. And again, we should avoid asking about children, which goes to a whole host of potential discriminatory issues and protected classes. Just some additional best practices as they relate to the initial job application process. Certainly we've hit on a number of standard employment application terms. Also, best to avoid automatic disqualifications. We shouldn't be disqualifying anybody, for example, with a criminal record, anybody who has been arrested. We need to make each of these determinations on a case-by-case basis. It's always best to have a job description with essential functions developed before you bring somebody on board, so that during the interview process and during the onboarding process, there'll be no dispute about what the job duties are and what the critical functions of the position are. We like to recommend that all employers have a structured interview process. Ask all interview candidates the same questions, give those interview candidates the same amount of time during the interview, so that they believe that they are being treated fairly, and you're giving each candidate the same sort of screening process. We recommend, to the extent possible, that you use offer letters, that after you've selected a candidate for hire, you make them a conditional offer of employment. That offer of employment would be conditioned on the successful completion of a background check and a drug test if that's part of your screening process. In addition, if you're going to require any of your employees to sign a non-compete, a non-solicitation, or a confidentiality agreement, we want to put that right in the offer letter, that the offer is conditioned upon the employee's execution of that agreement. There's a lot of value to providing all those conditions in writing at the time that you're making that conditional offer. Again, in the event that there's a dispute down the line, you'll have that piece of paper and that documentation as protection regarding what the parties' expectations were.
Adam, may I throw in a quick question? I know this may be old-fashioned. I don't think you can do this, but employers can't say we're going to hire you on for a probationary period, can they?
Employers do typically still apply a probationary period, but we have to be a little bit careful about what we communicate when we communicate a probationary period. We want to make clear that both before or during the probationary period and even after the probationary period, the employment will remain at will. However, during the 30, 60, 90-day probationary period, we're going to allow both sides to determine if this job is right for the employee, if the job is a good fit. So we still do see many employers having a probationary period. We just have to be careful that we're not implying some guarantee of employment after the probationary period ends.
Okay, thank you.
And it's a good question because outlining the probationary period is a good practice to include in the offer letter as well. Another practice that may or may not be right for your small business is social media screening, and we want to spend a little bit of time talking about that. We spent some time telling you what you need to avoid on job applications, and that's primarily the protected class information, those protected traits. Those protected traits cannot form the basis of our hiring decisions or any employment decisions, really. But in the hiring context, we want to avoid at all costs asking any information about the protected classes that you see on the screen. The idea is that in the event of an employment discrimination claim, oftentimes our best defense is that we didn't know the applicant's age, that we didn't know the applicant's religion, that we didn't know the applicant's sexual orientation. To the extent that we obtain that information, either on the job application or through social media screening, we lose the ability to argue that we didn't have that information. That would allow a disgruntled applicant to argue that it was the basis of our employment decision. A lot of folks are using social media in the hiring process now. Quite frankly, in my opinion, I don't think it's worth it for most entry-level jobs. You're far more likely to get non-job related information than you are to get anything actionable. You're going to get Facebook posts, potentially Twitter posts, and things like that. You're going to get all of this race, religion, sex, national origin, marital status information that you cannot rely on, and you may or may not get anything that is really going to help you make a decision about the applicant. But if you are going to do it, if you're going to Google your applicants, we do have some best practice advice for you here on slide 7. We recommend that you adopt a written policy that outlines what you're going to do and that the folks who are going to do it understand what the rules of the game are. If you use what we call a social media screener, someone who can go out and obtain this information from the internet, from the social media sites, and then bring back relevant job-related information to the decision makers, you can make sure that you're still preventing those decision makers from getting all that protected class information that we talked about, all that information that cannot and should not be part of the hiring process. If we develop up front the criteria or the fit criteria that we're looking for, then the social media screener can go out there and say, here's a report on this individual, and here's the 4 or 5 characteristics that we looked at. What do we want to look at when we're out there screening? Well, we can look at things like illegal drug use, poor work ethic, poor written or communication skills, the negative feelings about previous employers, discriminatory tendencies, and general poor judgment. If someone's on their Facebook page posting, I called in sick today, and then they're at the local amusement park, that is obviously something that we can base an employment decision on, and that's something that your social media screener would want to bring back to you. So again, in my mind, social media screening isn't going to be right for every job and every organization, but for those jobs and in those organizations where we're going to do it, we want to make sure that we're doing it correctly so that we continue to have the ability to argue that that protected class information, those protected traits, did not form the basis of any hiring decisions.
So quick question there. Do you possibly hire a contractor who does all the research and only provides you with information that's void of any of the discriminatory elements?
You can hire a contractor. You could use another management level employee in your organization that you've provided the list of fit information. For larger organizations, perhaps it's your human resources folks. You know, if you're working with a third-party staffing agency now, this may be something that they're able to do for you as well.
So there's a believed wall, even if it's one of your employees who knows more, if they don't provide it to the decision makers.
Absolutely.
Okay.
Absolutely. Good question. Let's turn to another popular screening method, and that's background checks and criminal history inquiries. And this is certainly a topic that has been pretty popular for regulatory agencies and the plaintiff's bar. Now, background checks and criminal history information is a changing landscape for us now, and there's two important principles to keep in mind. That is compliance with federal law and compliance with the state law. Compliance with the federal law may be necessary if you're conducting certain types of background information and if you're relying on criminal history information in the hiring process. We'll talk a little bit about what's required in that situation. Compliance with state law is going to be required to the extent that you see any criminal history information in the hiring process. We need to make sure that we're only relying on the types of criminal convictions that are permissible under Pennsylvania state law. Let's take a look at the federal requirements. Under the Fair Credit Reporting Act, we have certain obligations to disclose to applicants that we are going to obtain a background check, and we actually have to receive their written authorization. So if we use a third party, such as any one of the credit reporting agencies, to obtain a credit report, a criminal background report, any type of background information, this is what's known as a consumer report. So if we're getting this information from anybody other than ourselves sitting down and Googling this information, if we're getting it from a third party, the Fair Credit Reporting Act is probably going to apply. If it does apply and we are not following the next few steps that we're going to talk about, then there's potential ramifications, potential damages, lawsuits, and fines and penalties that can come with it. So again, if we're obtaining these reports from third parties, we need to make sure that we're complying with the Fair Credit Reporting Act. We need to provide a disclosure to the applicant that we're going to obtain a consumer report, and we're going to have the applicant sign an authorization allowing us to obtain that information. In addition, if we decide that we are not going to hire an applicant based on something that came to us in the consumer report, then we need to advise the applicant of that. We need to provide them what's known as the pre-adverse action notice. We basically provide them a copy of the report and say, based on something in this report, we're not going to hire you, and give them a reasonable period of time to object, whether or not we used the wrong Social Security number, the applicant, we had the wrong person, or the information in the credit report was wrong. If we don't hear anything from the applicant, then we could provide the adverse action notice that says we're now following through with our intention not to hire you based in part on what was contained in your consumer report, in the information that we obtained from that third party. Now, I understand that seems pretty onerous, but we can get the disclosure and the authorization at the time that we are getting the completed job application. In addition, it's only in those instances where we're disqualifying an applicant based on the consumer report information that we have to go through the pre-adverse action and the adverse action notification requirements. And if legal compliance enough wasn't a motivation for you, just keep in mind that this is a hotbed of activity for plaintiffs' counsel, and we have a reference to the Ellis versus Swift transportation case, which involved a class action lawsuit. It was a class of applicants who completed online applications to apply for Swift transportation. Swift was not obtaining the disclosure and authorization from the applicants and was not advising the applicants that it was obtaining these credit reports. In addition, it wasn't going through the pre-adverse or adverse action notification process. And just a few months back, SWIFT agreed to pay $4.4 million to settle this class action lawsuit over its unlawful background check process. So keep in mind that although many of us won't be hiring the number of employees that SWIFT is hiring, class action lawsuits in this area are certainly picking up steam and a potential negative consequence if we aren't compliant in this area. So think about whether or not you're getting a background check from a third party, and if so, what do you need to do to comply with the Fair Credit Reporting Act? In addition to complying with the federal law, we also have to keep in mind that we have to comply with Pennsylvania's Criminal History Records Information Act. Pennsylvania Criminal History Records Information Act essentially says that we can only consider felony and misdemeanor convictions if they relate to the candidate's suitability for employment. Let's break that down a little bit. Clearly, we can't rely just on arrest information, and this is consistent with the Equal Employment Opportunity Commission's view of the matter, that arrests that don't lead to convictions should not be considered because it's, essentially the employee has not been found to have done anything wrong. But if it's a felony or a misdemeanor conviction, not a summary offense, but a felony or a misdemeanor in Pennsylvania, we can rely on it if it would be, if we believe it would impact the candidate's ability to perform the job. The sort of easy one is a retail theft conviction for an applicant for a retail position. If an applicant had previously been convicted of a misdemeanor retail theft or a crime of dishonesty, we would have a strong argument that such an applicant would not be eligible to handle money or do the books at our store.
Hey, Adam, can I real quick ask a question on behalf of one of our listeners here?
Absolutely.
He's asking, if we search Pennsylvania's public court records online through the internet, do we need to comply with these rules as well?
That's a very good question. If the employer itself is obtaining information from publicly available websites and databases, the answer is no, you do not need to comply with the Fair Credit Reporting Act.
Okay, and I'm assuming that he would have to reply, if he's talking about criminal history here, he would have to comply with only following felonies or misdemeanors as they relate to the job.
That's absolutely correct. No matter where we get the information in Pennsylvania, we can only rely on felony and misdemeanor convictions that are job related.
And one other question here from somebody, a lady. Are we allowed to ask about traffic tickets if the job includes having a driver's license?
We are not allowed to ask about, we're not allowed to rely on summary offenses, including non-traffic violations, or including traffic violations in Pennsylvania.
So in other words, even if you're looking to hire a driver, if they have all sorts of tickets, you cannot use that?
Not if it doesn't rise to the level of a felony or a misdemeanor.
Wow. Okay. So go right ahead. Sorry.
No, that's okay. I mean, if there's, if we have a way to know that there's a history of accidents and things like that, I think that would be another matter. But the law is clear that we're not allowed to rely on summary offenses, which is what most traffic violations are. So if we do want to disqualify an applicant based on a felony or a misdemeanor conviction, we are going to need to provide them with a written notice that we intend to do so. And this comes as a surprise to a lot of employers in Pennsylvania, and I would venture to guess that we have a lot of non-compliance with this specific provision of Pennsylvania's Criminal History Records Information Act. We actually have to advise the candidate that we're disqualifying him or her because of the felony or the misdemeanor. So if you are going through that process, give some thought about whether or not you're relying on the conviction, whether or not you've selected a better candidate, and whether or not you have to provide that written notice to the candidate that you're not going to select him or her because of a felony or misdemeanor conviction. Okay? I mentioned briefly the Equal Employment Opportunities view of this. Again, the Equal Employment Opportunity Commission views negatively automatic disqualification policies. That is a policy that says if you have any felony, misdemeanor, summary offense, conviction, guilty plea, if you have a policy that disqualifies applicants automatically as a result of any criminal history record, that's going to be a violation of the Equal Employment Opportunities regulations and guidance in this area. They will take the position that such a policy has an adverse impact on minority candidates. Minority candidates, in the view of the EEOC, are far more likely to have criminal history information, criminal records, and as such, any automatic disqualification policy is going to have a disparate impact on minority candidates. So they view these very, very negatively and could result in a government investigation or, again, a class action lawsuit. What you want to do is, again, tailor those criminal history conviction inquiries to each job to determine whether or not the conviction is appropriate. And when you're evaluating it, you want to consider the nature of the crime, how long ago it was, if it's job related. And another thing to consider is, has the employee worked at another job for a number of years after the conviction? Do they have a good job record after that? That's something else that you want to consider. We also mentioned that the EEOC is very much opposed to any consideration of arrest. We can only consider those convictions for the reasons that we discussed previously. A real hot trend across the country and even in the state of Pennsylvania now are ban the box laws, and you may have heard the term ban the box. Ban the box simply means that you cannot ask about criminal history information on the job application. We removed the question that asks, have you been convicted of a crime? If so, check yes. That's the box that we're banning. As of October of 2016, 24 states had banned the box. Pennsylvania is not one of them. However, there's a number of local municipalities, cities, counties, etc., that have banned the box ordinances in place. This includes Philadelphia and Pittsburgh. If you're operating in Philadelphia and Pittsburgh, or in any state where there is a ban the box law, we have to remove the criminal history question from your job application. That doesn't mean that we necessarily cannot ask about criminal history information. It just changes the timing of that question. They have to remove it. We have to remove it from our job applications, but we can ask when we make a conditional offer of employment if there is any criminal history information. We can also conduct those background checks that we talked about to determine if there's any job-related felony or misdemeanors that exist. The idea here is that by removing it from the job application, if we're going to rely on it, we need to tell the employee that we're relying on it because we're doing the criminal background check after an offer of employment was made. This would not allow an employer to simply discard any job applicant who checked, yes, I have criminal history information. So it's another way of getting at these automatic disqualification policies and putting the onus on the employer to notify the applicant for the reason why he or she was not hired, which of course exposes us to additional legal liability. Okay, so make sure you know in the jurisdictions in which you operate if there is a ban the box provision. If so, now would be the time to take a look at your job applications to make sure that you're compliant in this area.
By the way, that doesn't mean that you might operate business there, but you're interviewing the person at your base, which might be somewhere else, not in those cities?
That's correct. I mean, you would have to have operations in the city or a municipality.
Like your business is in the city.
Exactly.
Okay.
Yep. That's a good question. Drug and alcohol testing continues to be a hot topic. Talking with employers lately, I hear a lot of lamenting about they can't find good candidates, and when they do, they can't find candidates that can pass the drug or alcohol testing process, which has come as a bit of a surprise to me. But a couple of key notes here. Drug tests are not medical examinations under the Americans with Disabilities Act, which means we do have the ability to screen applicants for drugs. Oftentimes, our clients, and we certainly recommend this, are not screening for alcohol during the pre-testing or the pre-hire stage because hopefully applicants aren't showing up under the influence of alcohol. But drugs stay in your system much longer, and it allows us to determine if this applicant is going to be a health and safety risk to the organization. We do recommend that any drug testing be post-offer. So again, in the offer letter, we would make that offer of employment contingent on successful completion of a drug test. We want to make sure that we're testing at the post-offer stage and disqualifying applicants who may test positive. For the most part, folks are using a Concentra or a WorkNet type of location to have the testing done for them. Okay. What about legalized marijuana use and medical marijuana now that it has come to Pennsylvania? Well, some states do prohibit you from taking action against an employee or an applicant for off-duty legal marijuana use. But in Pennsylvania, we are allowed to disqualify applicants who are using medical marijuana on the job, medical marijuana if they're under the influence of medical marijuana while they are working. However, we are prohibited from discriminating against anybody who is a certified user of medical marijuana. In other words, if someone has, just because they have a medical marijuana license, doesn't mean that we are allowed to exclude them from the hiring process. But we do need to give some thought to how we will test these individuals, what the basis for excluding them will be, and quite frankly, a lot of this is going to need to be worked out once the regulations are released by the new medical marijuana czar here in Harrisburg, where our office is. But just keep in mind that although we have a medical marijuana statute, that doesn't permit employees to work under the influence of medical marijuana or come to work in a way that they would be impaired by their medical marijuana use. And again, you just need to be aware of what the law is in your area if you're using pre-hire drug testing and if you're screening applicants for drugs prior to bringing them on board. Another area where government compliance can come to haunt us is the I-9 employment verification process. Most of us are familiar with the I-9 process. Most of us are complying with the I-9 employment verification process. Everyone's seen the forms. It's probably part of your standard operating procedures. What we've seen recently, however, is a government crackdown on I-9 compliance. We continue to see heavy enforcement in terms of investigation, I-9 reviews, and heavy-handed penalties for non-compliance. Even relatively minor violations, things like that, are resulting in are pretty heavy penalties. You know, if we have the timing wrong, if an employee starts to work for us and completes the I-9 several days later, that might be a technical violation. If we have missing or incorrect dates, signatures in the wrong place, inaccurate documents listed, specific improper re-verification or missing verification information. Even these very technical violations, when there's no actual employment verification dispute, can result in some heavy penalties. And as you see here on the next slide, fines ranging from $110 to $1,100 per violation. And if you have, if you have 2 or 3 years of employee history, you could have, pretty significant violations rack up relatively quickly. And as we noted, the government has been heavy-handed in this area, and they've been using the highest fines that they can levy under the law. Now would be a good time to sort of audit your I-9 process internally before anybody does it for you. Think about whether or not your I-9 practices are complying with the law. Are you retaining forms just for 3 years or the life of employment plus 1 year, whichever is longer? We only want to have those I-9s on hand that we are absolutely required to have. We don't want to be fined for an I-9 that should have been destroyed 2 years ago. So make sure that you have a retention plan in place. A lot of folks keep the I-9 in the personnel file, which is fine, but we also recommend that you keep a binder of I-9s, a copy of the I-9s, on hand for your auditing purposes, for purging purposes, and the event of an investigation. You can simply go to the binder rather than have to go through all of the personnel files to pull out the I-9 forms. Again, if you have the binder, you can also set up a tickler system to remind yourself to pull dated I-9 forms to move them out, so that if there is a technical violation on that one, at least you wouldn't be cited in the event of a government investigation. Also, some additional I-9 compliance best practices for you here on the screen. Consider whether or not, if you think you have I-9 issues, does it make sense to bring in an attorney? The attorney conducting the investigation would allow you to protect any potential problems by the attorney-client privilege, and would afford you the opportunity to get those I-9 compliance issues fixed and protected by privilege, so that in the event that the government were to come after you in the future, you could rely on that privilege to shield the problems and the fixes that you implemented. Certainly you want to have some procedures in place to make sure you're capturing the I-9 process, to make sure that the individuals who are completing the I-9s on behalf of the company understand what's required of them, even if that's just a short and sweet immigration compliance policy, a cheat sheet for them to make sure that they're obtaining the necessary information. And ask questions when they arise. If there's a dispute about the I-9 or an employee's eligibility, deal with that early on in the employment hiring process. If you have a question about an employee's authorization to work in the United States, it's best to deal with that early on before the employee has worked for you. If you have knowledge that an unauthorized individual is working in the United States and you're allowing that to happen, or ICE can make out an argument that you did that, you could be looking at some pretty significant violations and some pretty significant fines. So it's always best to address those issues and those questions at the time the employment begins, rather than wish you did in the event that there's a government investigation or someone comes to look at your I-9s. Okay? So deal with those issues early on, and sort of rip the Band-Aid off if you have a compliance issue. Just a couple of accommodated related issues. Again, this is an area where we're seeing not necessarily a government crackdown like we have seen in some of these other areas, but plaintiffs' counsel seem to be more willing and more interested in accommodation issues in the hiring process. The Americans with Disabilities Act requires that we provide reasonable accommodations to qualified individuals with a disability. That includes applicants and interviewees. Okay, most of us understand that if we have an employee that has a disability and the ADA applies to us, that we have to offer them certain accommodations. Sometimes we forget, though, that accommodations are required for applicants and interviewees. So if an applicant needs assistance getting to the interview room, for example, or assistance completing an online application or something like that due to a disability, we would have to provide those accommodations. In addition, we have to avoid asking questions that relate to medical information or medical inquiries. Now, we can't ask for the number of sick days taken if the employee or applicant is using prescription medication, if they've ever had a workers' compensation claim. Those are all questions that we need to avoid. In fact, the only question we can really ask is, are you able to perform the essential functions of the job with or without an accommodation? Beyond that, we really can't ask any medical or disability-related questions. Now, we can subject all applicants in the same job group to a medical examination or a physical examination if it's job-related. You know, if there's a physical requirement to the job, for example, in the warehouse, if moving boxes of 100 pounds or more is an essential functions of the job, we can require those employees and applicants to submit to a physical or a medical screening that would root out their ability to perform those essential functions. But generally speaking, we can't have medical inquiries for all employees unless they're job-related and consistent with business necessity. So there's a couple of things going on here under the ADA. It's the ability to provide an accommodation, and it's not asking medical inquiries inappropriately. In the pre-hire stage, what do you do if an applicant's disability is obvious? Or what do you do when an applicant interview indicates he or she has a disability and requires an accommodation? Well, if the applicant's disability is obvious, I would just continue to ask them the same question that we already know is lawful. Can you perform the essential functions of the job with or without a reasonable accommodation? And you may need to go into the interactive process with that applicant to discuss what types of accommodations would be available and what types of accommodations might work for him or her. So I think that is something that you would need to do if the disability is obvious. You probably want to work with legal counsel if you're going to offer an accommodation or deny an accommodation to an applicant. Okay, so if the applicant asks for one and you don't think you can provide it, probably a good opportunity to touch base with your legal counsel. If you are going to provide it, you may want to touch base with legal counsel as well to make sure that you're required to provide it and that there's no ramifications. If an applicant or an interviewee indicates that she requires some accommodation in the interview process, you should do everything you can to offer that in the interview process. I can't think of too many accommodations allowing an applicant to be considered for the job that wouldn't necessarily be reasonable and appropriate. So we should work to provide those types of accommodations, if at all possible.
We do have a question, and it's not quite in the theme of what you're doing here, but let me throw it out quickly, and maybe you could just address it. Are there rules, and I don't know if this is in your presentation, or when you're checking someone's references, are there do's and don'ts there as well?
Yeah, for the most part, reference checks are going to be limited not by what you can ask, but by what the person giving you the reference is willing to tell you. But when you're checking references, you want to stick to the main principles that we've discussed throughout the morning. You want to avoid protected class information. Okay, so you want to avoid questions about the age, the ethnicity, the national origin, workers' compensation claim, children, pregnancy, marital status, all of those things. You want to stick to specific job-related inquiries and questions.
Okay.
You know, does this employee have good judgment? Does this employee, is this employee eligible for rehire? What was the last job held? What were their performance evaluations like? All those job-related questions are certainly in bounds and up for grabs. You probably, a good practice in this area is to keep a list of questions that you ask each reference. That way, if there ever is a dispute about what you asked the reference, you can say, I follow this script here, and here it is. There's 5 questions I asked each reference, and here's the answers that I was provided in this specific case.
That's a good idea.
That would be strong evidence that there were no out-of-bounds questions as well. All right, so we talked about accommodating medical issues and the high-wire act that could be. We also had a Supreme Court, United States Supreme Court decision last year about accommodating religious concerns of applicants. Last year, an applicant took Abercrombie & Fitch all the way to the United States Supreme Court. Abercrombie refused to hire a Muslim candidate who wore a headscarf because Abercrombie had a policy that prohibited employees from wearing anything on their heads. They called it their look policy. And Abercrombie said, we are not going to hire this candidate because she's required to wear a headscarf. And the Supreme Court said you can't deny employees employment on the basis of religious, sincerely held religious beliefs, just like you can't discriminate against sincerely held religious beliefs. So keep in mind that your policies, your uniform policies, may need to yield to religious accommodation issues. Now, some employees have argued that their hairstyles or their haircuts require accommodation and that their employers need to yield to that. That's not necessarily the case. For example, there was a case in Pennsylvania involving dreadlocks where the employee attempted to argue that his dreadlocks were required by his Rastafarian, not religious beliefs, but personal beliefs, and the court said, no, the employer has the right to require that you keep your hair neatly groomed and trimmed. To the extent that that's not a religious accommodation to keep dreadlocks, that's a lawful basis for the employer to exclude you from the employment process. But to the extent that there is a religious concern that comes up against your uniform policy, you may need to yield to that religious request. Recently, Subway stores were sued over their no facial piercings policy, and ultimately, I think Subway would have prevailed on that to the extent that the facial piercings were not part of a sincerely held religious belief. However, Subway ultimately reversed course, I think, due to negative publicity. So there's a lot of sort of shifting sands in the area of religious accommodations and uniform policies. But the basic principle is, if it's a sincerely held religious belief, we may have a duty to provide an accommodation by altering our policy for employees in those instances. We have to provide those accommodations, but we don't have to provide them to the extent that we do medical accommodations. The religious accommodations are subject to a de minimis cost or burden limit. So in other words, if it would put us out even slightly, we may not need to accommodate it. In the instance of the headscarf, the Supreme Court did say that is something that Abercrombie would have to accommodate by modifying its dress code or its look policy to allow an employee to wear the headscarf. So again, if you get into a situation where you're going back and forth with an employee seeking a religious accommodation, this is probably one of the times where you want to pick up the phone and consult legal counsel before you end up before the Equal Employment Opportunity Commission. Just keep in mind that any sort of automatic disqualification based on uniform or other types of concerns can land you in hot water. Okay? I think the final topic that we have for you this morning are union organizing concerns and union salting. So just a quick legal note that under the National Labor Relations Act, and specifically Section 7, employees have the right to form, join, or assist union organizations to bargain collectively and to engage in other concerted activities for the purposes of collective bargaining. It basically means that employees have the right to form and join unions, and these rights under Section 7 also protect precursors to union activities. Think of the situation where one or more employees is trying to begin the union organization process. Sometimes that happens with existing employees who will begin an organizing drive within your workforce. In other cases, a union salt will come from outside of your organization, will try to infiltrate your workforce, and then begin to organize your workers. Salts are professional paid union members who apply for jobs with your company. Okay? Oftentimes they put it right on their application. I have been a business agent for Teamsters Local 123 for the last 25 years. I have 35 years of retail experience or something like that. They're often highly qualified individuals, and they often try to force you to hire them, or if you deny them employment, they'll say that you denied them employment strictly based on their union affiliation. So if they are hired, you get to deal with an attempting union organizing campaign, and if they're not hired, they potentially file an unfair labor practice charge alleging that you discriminated against them because of their union affiliation. Seems like you're in a bit of a catch-22 here, and that's because you are. However, nothing in the law says that you have to fill any job in any particular case. So if you decide not to fill a position and it's for legitimate business reasons, it may be a hard case for them to make out an unfair labor practice charge if you simply decided not to hire a physician for business reasons. Okay. But what happens if an applicant is hired, she reads your policy manual and says she will not sign, she claims that confidentiality policy violates the National Labor Relations Act, but she filled out all of the other forms correctly? What do you do? Well, union salts are looking to get fired. One of the things that they're looking to do is to have you fire them so that they can trigger an organizing campaign, that they can have a platform for which to organize your employees and come after you. The bottom line is, if you require all employees to sign a copy of the employee handbook, you should continue to do that. You obviously want to make sure that your employee policies and procedures are lawful and compliant. And again, to the extent that you have an employee handbook, this is something you want to have reviewed by counsel. If you haven't had it reviewed by counsel ever or in a while, now would be the time to do that. But assuming that your policies and procedures are lawful, you can take action against this employee for refusing to abide by your policies. But again, if the union person is a salt, you might be walking right into a trap. If you require, so here's some best practices now, turning to slide number 29. Some best practices to help deal with salting issues. A lot of people are going to an online application now. With an online application, you're far more likely to get a salting campaign. If applicants are required to come to your place of business and sign a physical application form in order to be considered, it's less likely that a SALT is going to sign or complete that application. They're just not going to go through that process. In addition, you should only hire when you have a vacant position. And you should put right on your job application that an application will only be considered active for 30 days or 6 months. So if you get a bunch of SALT applications and then you decide that you're not going to fill a position for a period of time due to business constraints, when you go to hire a year later, you won't have to consider those SALT applications that may still be on file, because our application makes clear that they were only active and considered for 90 days. All right, that limitation right on the application is a really solid practice to help you avoid an aggressive salting campaign. Also, avoid newspaper and radio advertisements. Go in favor of word of mouth of employee referrals. Oftentimes, if a union organizer hears about, either in the newspaper or potentially on the radio, which is what I've seen a lot here in central Pennsylvania, if there's a radio advertisement, the union organizers will see that as an opportunity to send in a SALT and get rid of those applications after a period of time. Again, only consider them active for 30, 60, 90 days, maybe 6 months, and then make sure that you abide by that practice and get rid of those applications when they're no longer active. And remember, if SALTs are hired, they do have to play by the rules, and they do have to abide by your employee handbook and follow all the rules of all your other company employees. You have to implement those rules consistently, but as long as you do that, you should be able to withstand a SALT who's basically begging to get fired. We have not seen a great deal of salting outside of the construction industry, but where we will see it occasionally are in healthcare, food service, and places like that, where SEIU and some other union organizers are continuing to attempt to organize employees and infiltrate the workforce. Okay, so salting is a concern, and there are some basic steps you can take to help keep your company in a position to deal with those types of issues.
Is it possible, just briefly, Adam, that someone, you may not know their background and just hire them and suddenly that you find out that they are a SALT?
Yeah, typically they'll make no bones about it in their employment application, because again, them not getting selected is almost as good as them getting selected and then getting fired. But there are times where we may not know that somebody is a SALT when we make an offer of employment. In that instance, I would say that you just need to treat them just like any other employee, and at that point in time where they violate your policies, if the opportunity presents itself, we would look to terminate the employment. That would need to be consistent, though, with how we've handled similar situations in the past.
So you're likely to know it, though, because they're more likely to make you aware.
They will make themselves known sooner rather than later.
Okay.
Absolutely. So with that, we have a few more minutes, and I'll be happy to answer any additional questions. In addition, we put up some information here about our labor and employment blog. We post fairly regularly about developments in Pennsylvania labor and employment law, as well as national labor and employment law. It's a good place for you to go and do some searches and or sign up to receive alerts when we post new material. In addition, I've listed my contact information up there. Again, I'll be happy to answer any questions that you have. If you want to call me or shoot me an email, anything related to the topic today or information generally, I'd be happy to try to help get your questions answered.
Well, listen, I want to thank you so much. It was really informative and excellent. I want to thank everyone for joining. Let me make a quick mention. I am recording this, and I shall upload it to YouTube and make it available. It may take a day or two just because it's a slow upload, but I will also email it to you as well, anyone online, so that if you want to review the slides, you'll have them. One last mention, NFIB is doing a webinar tomorrow. that relates to the overtime rule. And even though things are in flux and there's some bills that would delay it and we have a new president-elect, there is one of our attorneys nationally who will be doing a webinar on that topic and complying by December 1. If you want to go online to nfib.com and go in the webinar section, you can sign up for that. Anyway, with that, Adam, thank you so much, and we appreciate, I don't see any new questions, so if we get any further ones after the fact, I shall email them to you. Thank you, folks, and have a great day. Bye-bye.
Thank you.